Welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. So we're talking about Richard Allen, Indiana versus Richard Allen. And in this episode, we're going to be talking about or reading through some motions that the state has just recently filed in order to halt Richard Allen's defense. So if you've been following along, um, sort of recently, Nick McClelland had filed the prosecutor. He's pictured here on the thumbnail. So obviously, Richard Allen is in the yellow with the vest, and Nick McClelland is the other one pictured. He is the prosecutor. So he filed a motion in limine, which basically he's trying to eliminate certain topics of discussion during the Delphi trial, which would include talks about Odinism, sacrificial type um, uh, ceremonies, when it comes to Odinism, cults, that kind of thing, they don't want to discuss. They also named multiple people who are or have been suspects in the investigation of the crimes of taking the lives of Abby and Libby. But this prosecution wants to prevent Richard Allen from saying any of those names, like Patrick Westfall, Brad Holder, those types of names. So we don't know why. I mean, we do know why. What does the state have to hide so much? It seems very odd that they have, they want all of this hidden. So, in an effort to continue to paralyze Richard Allen's legal team from doing certain things, they just filed this motion to quash. Is there a date on here? No. These just came out on the 27th, I believe, of this week. So August 27th. So motion to quash subpoena. So in the very last episode, there were, I believe, two other motions to quash, and this had to do with subpoenas regarding individuals that the defense is trying to depose. So they want a deposition of certain people in their case, and that may or may not help them in their case. That's why they're doing it. They have certain things that they want to, learn. And on the record, a deposition is just as legally binding as like being on the stand. It's just that there's no judge there. You're there with two attorneys, but you are sworn in. So whatever you say is testimony. So the prosecution is trying to quash the subpoenas. So the subpoena meaning it is the legal document, the legal order saying we need you here on this date and this time because we want to depose you. So Nick McClelland says, let's quash those subpoenas so that these people don't get deposed. We don't want the defense deposing these people. So now this is the, I believe, third motion to quash coming from maybe fourth, I can't remember, coming from the prosecution. And here, let's read through it. So Jessica Fiddler, MD, by counsel pursuant to Indiana Trial Rule 45 and Indiana Trial Rule 26, respectively, moves this court. So this is actually from Jessica Fiddler. This is not from, that's interesting. This is not from Nick McClelland. I apologize. I take my words back. This particular document was written by the attorneys of Jessica Fiddler, MD, who was trying to, or who somebody has deposed. So let's find out. Jessica Fiddler, MD, by counsel pursuant to these rules, moves this court to quash the subpoena ad testicandum. I don't know, testificandum? Whatever that means, something about testifying, issued to her by the defendant in the above captioned matter. So it was a subpoena coming from the defense's side to this Jessica Fiddler to have a deposition completed today. It's supposed to be today, as I record this, 8/28 of 2024. So, in support of this motion, Dr. Fiddler states as follows. Dr. Fiddler was served with a subpoena commanding her to appear for a deposition on August 28th, 2024 in the Carroll County Courthouse Circuit Court Jury Room. The subpoena was issued in connection with a criminal proceeding in which Dr. Fiddler is not a party. This subpoena does not comply with Indiana Trial Rule 45 D2, which requires the deponent to attend a deposition only in the county in which they reside or in which they conduct business. Dr. Fiddler is a physician practicing medicine in Greencastle, Putnam County. So she's not in Carroll County. So because it's a different county, she says she can't go or doesn't need to go. That doesn't mean that she shouldn't have to sit for a deposition, but anyways, they could just change potentially. Anyways, so the subpoena also provided only 9 days notice before the scheduled deposition. Dr. Fiddler is a licensed medical doctor practicing in Greencastle, Indiana, with a demanding patient schedule. The short notice period is insufficient to allow her to adjust her professional obligations and comply with the subpoena without significant disruption. Come on, that's plenty of time you can call people. 9 days? I don't know. What does she want? The trial's coming up and they're just finishing up discovery. Like they or still haven't finished discovery, I should say. They're still going, the defense is still going through the mess of discovery that the state has turned over. All right, so under Indiana law, reasonable notice for serving a subpoena to a witness, particularly in the context of depositions, is not explicably defined by a specific number of days. However, Indiana courts have interpreted reasonable notice to mean notice that is reasonably calculated under all the circumstances to afford the interested parties an opportunity to present their objections and must reasonably convey the required information to the effective party. That's according to Squibb versus State et al. Davis, or State X rel Davis, whatever that is. All right. So Indiana Trial Rule 30 and Rule 45 provide additional guidance regarding the scheduling of depositions. Rule 30b1 requires that notice of a deposition must be given to all parties before a subpoena can be issued. The Elkhart County Rules of Court, where's Elkhart County coming from, further specify that unless otherwise agreed by counsel or authorized by the court, no deposition shall be scheduled on less than 10 days' notice. So you're going to fault them for being 1 day off. Although these specific rules pertain to Elkhart County, for a county that's not even theirs, they reflect a general standard that is instructive for jurisdictions in Indiana, including Carroll County, particularly when considering what constitutes reasonable notice. How does Elkhart County give a general standard for all other counties? I don't think so. I don't know if that's a very solid argument, but okay. The subpoena served on Dr. Fiddler did not include the necessary witness and mileage fees as required by Indiana law, Indiana codes, whatever, govern witness fees and mileage fees, which apply to both civil and criminal proceedings. Indiana Code chapters 33, 17, 8 extends these provisions to criminal cases, ensuring that witnesses in criminal proceedings, including those participating in depositions, are entitled to the same statutory fees as in civil cases. For a deposition during her normal business days, Dr. Fiddler charges $350 per hour for a deposition. Okay, that's great. They're subpoenaing you. You shouldn't charge for a deposition. You have to be there by law. How is she charging for depositions? I guess if that's like her, if she's hired on as an expert, okay. But she can't charge for a deposition that she's being required to come to in the court of law. I don't think. Unless I'm wrong on that. Somebody say something, but I don't know. Witness fees and mileage fees. So they want to pay her fee of a deposition for taking a deposition. That's ridiculous. In light of the insufficient notice period, the professional obligations of Dr. Fiddler, and the failure to render the required fees, the subpoena is unreasonable, burdensome, and legally deficient. I don't think this is a great argument. I don't think any of this is a great argument, but we'll see. For these reasons, Dr. Fiddler respectfully requests that this court quash the subpoena issued to her and relieve her of any obligation to appear for the deposition on August 28th. The failure to provide reasonable notice and the omission of mandatory fees each independently justify quashing the subpoena. Why is she fighting it so hard? Dr. Jessica Fiddler, by counsel, pursuant to Indiana Trial Rule 45 and Indiana Trial Rule 26, respectfully requests that the court grant the relief request herein and all other just and proper relief. So, what's to stop the defense from saying, okay, fine, we'll give you your 10 days notice now and your reimbursement. Now what? And we'll put it in your county. Now what? Now what are your excuses? So what if they remedy all these things that she's asking for, which I think are stupid, if you ask me? I mean, I think the only thing that might have some legroom is the jurisdiction because she's not in the same county or whatever. So that might affect something. But she's trying to get the subpoena quashed herself, which I find interesting. She didn't go through the state like the state did, two others. So I don't know. I don't know what to make of that. This is also coming from Peter Pogue, the Pogue Law, and he is a notice of temporary or limited representation. He's just saying, I am representing Ms. or Dr. Fiddler, who doesn't want to be deposed for some reason. I don't know. But here, this is from the state. So this is the state's response to the defendant's memorandum of law. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully responds to the defendant's memorandum of law in support of admission of evidence of alternative theories of the crime and third-party perpetrators. So again, he doesn't want anything about these third-party culprits. He doesn't want them to use a third-party culprit defense, which is everyone's right in this country to say, I didn't do it, someone else did. So the legal issue involved was previously articulated both in the state's motion in limine and in the state's opening statement at the August 1st hearing. In order to present evidence in relation to the third party at trial, the defense must show a direct material connection between the third party and the crime. And I believe that all the Franks memos do that. But, that's just me. I read them. Unlike Judge Gull, who admittedly said she didn't even read through the first Franks. And that's why, and she never responded. And that's why all these times they were like, Judge, can you please, under judicial notice, take these Franks hearings? And because she wouldn't respond, she wouldn't read them. So she didn't want to hear that somebody else could be responsible for this crime. And I think McClelland is fighting adamantly to make Richard Allen fit as the suspect, even though he's also been on record stating that there's been multiple people suspected to be involved in the crimes. So when the defense comes forward and says, here's a bunch of multiple people that probably did the crime, and here's why, and here's how they're related, and oh yeah, one of the guys, his son dated the girl, was dating the girl at the time, one of the victims. There is a direct correlation to the victims and the third party culprits right there. There's no direct relation to Richard Allen and the victims. So it's just so infuriating, and it makes you wonder what's going on in Delphi. So the connection must be based on more than hearsay, speculation, rumors, conjecture, or theory. It must be based on reliable evidence that draws a material connection between the party and the crime. Well, if law enforcement didn't accidentally record over days worth of interviews with these suspects, maybe we would have more evidence to prove that they were involved. And if they extracted their phones and did the due diligence of law enforcement that they're supposed to do in an investigation, we wouldn't be sitting here right now talking about this. So it must be based on reliable evidence that draws a material connection between the party and the crime. The Indiana Supreme Court summed up this long-lasting principle as follows. In the context of third-party motive evidence, these rules are grounded in the widely accepted principle that before evidence of a third party is admissible, the defendant must show connection between the third party and the crime. I feel like I'm losing my mind here because I feel like that's already been done. The defense, in several hours of presentation of evidence, supplemented by numerous documents and depositions, failed to present any evidence that links Odinism, Brad Holder, Patrick Westfall, or any of the individuals listed in the state's motion in limine to these to these crimes. I'm not supposed to say that word on YouTube. So they're saying that they failed to show any evidence that links Odinism between the third party culprit, which that's the one big connection they all have is Odinism. Sorry to get so mad, but the Delphi Vinlander group is all Brad Holder, Patrick Westfall, and Johnny Messer. Johnny Messer is the recruiter, and he also knows Elvis Field, Rod Abram, and Ned Smith, the Rushville. That's the Rushville crew, the Rushville Vinlander crew. They're the wannabe Vinlanders. They want to join the Delphi crew. So that's the connection. And we know that Logan Holder, right? Logan is the son's name. Brad Holder's son, Logan, was dating Abby at the time. So, I mean, connections, links. I don't know what more Nick McLeland needs, but it's all been laid out. A case cited by the defense in their memorandum is very instructive. The case, coincidentally named Allen versus State, involved a robbery, a triple homicide at an Osco drugstore in South Bend. The Court of Appeals ruled that it was reversible error not to allow the testimony of witness Bethel regarding a third-party suspect, Crenshaw. Bethel testified outside the presence of the jury to the following, that he and Crenshaw had cased the Osco store several days before the homicides in anticipation of robbing it, that Bethel, on the very morning of the homicides, observed Crenshaw only blocks away from the Oscos and coming from the direction of the Oscos. You just say Osco. You don't say the Oscos. You just say coming from the direction of Osco. I live in Chicago, in the Chicago area. We have Jewel Osco also. So you don't say I'm going to the Jewels, but people do say that here, and it's really annoying. So I guess he would be one of those people if he lived in Chicago. He would call it the Jewels. Anyways, okay, so only blocks away from Osco and coming from the direction of Osco, and then heard Crenshaw say he had just got some money and people were KILL'd. That Crenshaw paid cash for hotel rooms the evening following the robbery, and finally, on the evening of the homicides, Crenshaw told Bethel that the situation at Osco had gone bad and 3 people were no longer alive. So in Joyner versus, I don't know what that has to do with anything. In Joyner versus State, the Indiana Supreme Court ruled that it was error not to allow third-party evidence regarding a coworker of the homicide victim. However, the excluded evidence that would have been admissible at trial consisted of proof that a third-party suspect was married and having an affair with the victim. They had intimate relations with the victim the evening before her disappearance, had argued with her the day of the disappearance, was tardy to work the day after her disappearance, had falsified his time card the day of her disappearance, and was a 98% match to the hair found inside of the plastic bag found over the victim's head when her body was discovered, hair that had been determined not to belong to either the victim or the defendant. By contrast, as the August 1st hearing demonstrated, the defense has only offered up speculation supported by conjecture. I don't think so. And buttressed by what ifs. Without evidence, material or otherwise, that these were ritualistic homicides, the defense speculates that various social media posts by Brad Holder suggest he could be interested in Odin-based rituals and therefore could be connected to the crime scene. Not just that, but he had pictures very close in time to the homicides that replicated what was found at the crime scene. How would he know that? How would he know what was at the crime scene? That's not a coincidence. There's how many runes in the Odinist whatever, and here he knows what runes were used in combination to one another. How did he know that? Unless he was there. That's the issue. Not that he may have some interest in Odinism because, well, first of all, you just said earlier that there were no ties to Odinism in Brad Holder, but now you're taking it back and saying that some social media posts do speculate that he had Odinist ties or whatever. I don't know. He literally has things on his Facebook post like saying praise the gods, or hail the gods, hail Odin, hail Thor, hail all these god names. So to say that he's not into Odinism, I think is a little disingenuous, Nick. All right, so then the defense add the conjecture that since Elvis Fields and Holder have vaguely similar social media posts and both might have a passing acquaintance with a man named Johnny Messer, a connection, not just a passing acquaintance, but a connection between the two, and Johnny Messer and Brad Holder and Patrick Westfall were all really good friends up until the crimes happened. Sometime that month that it happened, they had a falling out. At least Brad Holder and Patrick Westfall did, and they no longer speak. So this isn't a what if scenario. These things did happen. There's a lot of evidence corroborating what the defense is putting forth in their Frank's motions. And Nick is basically just going, oh, well, you're saying this, but that doesn't mean anything. Well, no, they're saying some really important things. And I don't know. I don't know what they're seeing that we're not. All right, so then the defense add the conjecture that since Elvis Fields and Holder have vaguely similar posts that both have a passing acquaintance with the name Johnny Messer, then perhaps Elvis Fields may possibly know Holder. The defense then adds a what if unsupported by evidence, i.e., what if the crime took place on the following day in order to get around the inconvenient fact that Holder has an alibi for the time when the homicides, according to the police investigation, occurred. But the defense is allowed to say, we don't believe the homicides took place at the time police say that they did. The defense has a right to say this is more likely when the time was based on geofencing data and other data that they might bring to court. They have a right to do that. So again, why is Nick trying to cut them off at the knees with their defense? It's enraging to me. The defense continues down this path of speculation as it relates to the other individuals listed in the motion in limine, failing to tie any of the individuals to the crime. I don't know about that. Again, I see it totally differently. The state further showed through irrefutable evidence that none of the third-party suspects listed in by the defense were in the area of the crime scene on the day of the homicides, and that none of them have any ties to the crime scene. The state was able to show that there was no material connection between Odinism, Brad Holder, Elvis Fields, Patrick Westfall, Johnny Messer, and the homicides. Uh, Whatever. He says it's unequivocal. Sure, irrefutable. Yeah, whatever. Merely because law enforcement in the days, weeks, and months following the homicides pursued and followed up on various tips, rumors, and theories does not mean that the trier of fact should be misled, confused, or distracted by tips, rumors, and theories unsupported by admissible evidence. As the August 1st hearing made clear, the probative value of the third party evidence offered by the defense is greatly outweighed by unfair prejudice, confusion of the issues, and potential to mislead the jury. Therefore, the widely accepted principle Pele cites should be applied. Wherefore, the state requests the court to grant the state's motion in limine in regard to the third party evidence proffered by the defense and for all other just and proper relief in the premises. So they're saying it's unfair and it prejudices the defense, or it prejudices uh, the jury. Um, Sorry, hold on. Okay, so August 1st, here, I lost my thought. Let me get it back. So, as the August 1st hearing made clear, the probative value of the third party evidence offered by the defense is greatly outweighed by unfair prejudice. So, they're saying that it would be an unfair prejudice if they offered this information about the Odinist, and it's just going to confuse and mislead the jury, and they don't want to do that. But in my opinion, I think it confuses and misleads the jury if you tell them all these other people were originally investigated at the beginning, and then suddenly all their footage just disappeared. You have to be able to, like, bring that up as an attorney to defend your client. You have to say, hey, weren't there other people that suddenly just they're they were in under investigation, but then suddenly, like, they were just not under your radar anymore? And why is that? What cleared them? I think that the public has a right to know these things because it's out there. This is all in public documents now, and we deserve to know. I, just everyone in the state of Indiana should be furious. And anyone in this country seeing what's going on in Delphi should be furious with what is potentially happening with law enforcement and Judge Gull and possible corruption, misconduct, all sorts of things going on there. So let me know in the comments below what you think. Is Judge Gull going to grant the motion in limine and basically eliminate the defense from putting on a defense? What do you guys think? Let me know in the comments below, and I will see you guys in the next one. Thank you so much for watching. Please hit that like button on your way out. Take care, guys. Bye now.